sub-weekly bazaar under the Juria Anchalik Panchayat by allotment order dated 21/1/2019. On the basis of a house construction permission. Where is that? On the basis of a house construction permission dated 25/6/2019, issued by the Executive Officer Area Anchalik. The petitioner constructed what? How did you construct? With what? Cement? Iron rod? What? With Silpolin? With what? Mr. Council, I want to know whether you constructed it with Silpolin sheet or RCC. Silpolin sheet. The petitioners constructed a temporary shop over the plot number 89 by using Silpolin sheet, etc. However, on 11/2/2025, some miscreants at the behest of the Bazaar Committee of the Arabari Sub-Weekly Bazaar demolished the shops of the petition. Though the petition submitted an FIR to the OC Julia PS and a representation dated 20/03/2025 to the Executive Officer Julia Anchalik Panchayat for allotment of an alternative plot of land for establishment of the petitioner's shop. Present petition can be disposed of. The direction is issued to the response authority to take a decision on the petitioner's representation. Mr. A.K. Ghosh appearing on behalf of Mr. S. Datta, Senate Counsel for the respondent, all 2, 4, 5, and 6, and Mr. S.R. Barwa for point number 3, and Mr. P. J. Hunting for point number 1. Submit that there were no objections to the prayer made by the petitioner's counsel. However, there is nothing to show that the submissions made by the petitioner's counsel and the averments made in the petition are true. On considering the submissions made by the counsel for the party, this court is of the view that the present petition can be disposed of the motion stated. Without going into the merits of the case and coming to a finding as to whether the averments made by the petitioner in his petition are true or not. This court is of the view that the petitioner's representation dated 20/03/2025 should and regulated. Now the regulation, then now the regulation, some official from the office of the circle officer, Teshpur Revenue Circle, accompanied by some police personnel, came to his business premises on 18/7/2024 and ordered him to close the shop immediately. And immediately come out without giving any order of closure, without giving any written order to the petitioner. Then continue. To the circle officer Tezpur. And also Panchayat also. No. So the circle officer Tezpur Revenue. 20 July 2025 to the Executive Officer Julia Anchalik Panchayat for allotment of an alternative plot of land for establishment of the petitioner's shop. So the circle officer Tezpur Revenue Circle. And also Panchayat also. No. So the circle officer Tezpur Revenue Circle. 20 July 2025 to the Executive Officer Julia Anchalik Panchayat for allotment of an alternative plot of land for establishment of the petitioner's shop. And also Panchayat also. to give to the petitioner in writing the reasons for directing the petitioner to close the license breach. So that the petitioner can make a reply to the same. Mr. J. Andik, counsel for the respondents number one and two. Circle office also.
Only Panchayat cannot
I know. So one and two.
only two lots.
One is Panchayat and Rural Secretary.
There is separate coming from.
Okay. Mr. J. Handik, learned counsel for the circle officer, Tesco Revenue Circle submit that he has got no objection to the prayer made by the petitioner. That's correct. In view of the consent of the parties, the circle officer, Tesco Revenue Circle, is to furnish the petitioner the order, the reasons and the written order for directing him to close his license breach shop within a period of 1 week from the date of receipt of a certified copy of the law. You do not know the
one people that is my livelihood. I'm living on that poor man. Why
Okay, you say just say within a period of 3 days from the date of receipt of a certified copy of the law. Till then. No, you come after that. We do not know what's going to happen. You might have been selling some tiger's meat instead of some. You do not. You do not. No. Acha. Circle officer. They pay 3 days. No. That election will do.
That next Friday, 11 is the counting day. They are be busy in that election.
He just has to give the written full stop. What have I said?
Let it be as per his prayer, let it be within 50 days, then my lord kindly allow to continue with the lab.
What meat shop is it? What have I said? Okay. Within a period of today is what date? Today is 16th.
10 lots to my lord, 3 days before. 3 days, see my lord. See my lord. Why we can't do close mala that close and notice to the mala
No, nothing has been given. That's what he said.
That's a doctor.
Or should we ask you to bring the reasons by Thursday? So we doesn't have to go. I think better. And then right. What have I said? No, next. On considering the issue raised by the petitioner, this court directs the uh, revenue circle. Yeah, the circle officer. Tesco Revenue Circle. To this court directs Mr. J. Hardik, the learned counsel for the circle officer, Tesco Revenue Circle, to give written reasons as to why the petitioner shop has been directed to be closed. The same should be given by Thursday, this Thursday. It is also made clear that if no written instruction is provided to this court on Thursday, the prayer for the interim prayer made for opening the oral interim prayer made for opening the shop on the said date shall be decided. Give a copy. Thursday.
It's not a very challenging of communication by the manager. What has happened is that the petitioners,
Which item?
item number 9.
So we issue notice, what is there to be done?
Something because what has happened under the Trade Unions Act and the bylaws, the general manager is a stranger to the entire process. So he one in the election process is coming.
No, we see, this is a question of fact.
Yes, sir.
How will we know?
That is why the notice on the green as well. If they file their affidavit, then my increase can be done.
If they file the affidavit, entire thing can be considered. Huh?
I have already.
Is there any alternative remedy available? This is a question of fact, basically. In basic cases, what? That the number of ballot papers are found to be more than the votes cast.
I have in fact filed the writing suit challenging the election. Here I am challenging the communication. Lordship, I kindly have a look at the communication at page number 71. Because the general body with the Supreme Authority of the Union rests, it has not declared the election. But Lordship, I kindly have a look at the communication.
Yes.
He has preempted the decision, the result of the election. The list of newly elected central office bearers of this NFLA Mazdoor Union is forwarded here for information and guidance. The central office bearers were elected in the 14th biennial and 66th annual general meeting of the so-and-so held at Maligaon from 3rd April to 5th April 2020. Now, kindly have a look at the vote tabulation sheet at page number 57 for one. There the observer has clearly said that the results cannot be declared.
The list of duly sent out the form is let's say 14 minus 16, 5th April 2025. What do you want to say with this?
So the results have not been declared by the union. The mail manager of the NFA, he has declared the results unilaterally. Lordship, kindly have a look at the vote tabulation sheet at page number 7.
But then that is subject to again whether the ballot and the vote are same.
No, results are not been declared. That is.
So how does it matter? How is it? How does it matter? Do we declare the entire the entire exercise what vacated or what?
Till because you're also as per the bylaws of the union, which came as per the Supreme Authority of the union led to the general body. The general body has to declare the result. Because the general body has not yet declared the result. Now, without waiting for the declaration of results, what this Indian communication has done is taken it upon itself. Lordship will finally see the second sentence. The central office bearers were elected. They were never elected.
I don't know.
That is why now it is and notice of the experiment.
Because so you're challenging this page 71.
Only his authority, not the results. Because under the Trade Unions Act as well as the bylaws of the state.
Does not Mr. K.B. Pathak learn after for the petition? The elections is that in the elections for constituting the working committee was conducted during the 14th biennial general meeting held at Maligaon from 3 to 5 April 2025. The petitioners were candidates for the post of General Secretary or Assistant General Secretary of Organizing Secretary. However, during the counting of votes, it came to light that the number of ballot papers were found to be more than the number of votes actually cast. Correct. It happens that the same has been put to challenge by the petitioners in title suit number.
Filing number 127.
Title suit bearing filing number
127
127 stroke 2025.
The court of the civil judge junior division at the point.
For civil judge junior division. It submits that the results of the election are to be announced by the general body. General body of the All India Railwaymen.
No, not NFLA Mazdoor Union.
By the NF Railway Mazdoor Union. However, the respondent number
4 and 5.
Now this is
4 and 5 acting on behalf of the respondent. 4 and 5. Because he has acted on behalf of the company.
how will the respondent number 5 have taken upon themselves to announce the results of the 14th biennial general meeting. So they are third party to the thing. But how does it affect you?
Because your option, when a working committee is constituted, various privileges and protections are granted to them by the employer. Without waiting for the final declaration, they have proceeded on the basis that the executed results are the final.
Anyway, right, issue notice returnable in COVID. Means are they accept notice on behalf of 1 to 9? Anybody else is there?
Private respondents are
I
there.
think they will take steps for service of notice upon the private upon the respondents number 10 to 44.
8, 9 also have people. The unions also have made a point.
So you have 1 to 7 only.
Yes,
No, 1 to 8, 6, 1 to 6.
1 to 6.
7, can you take for 7? No, I don't think so. 1 to 6. The petitioner takes steps for service of notice upon the respondents number 7 to 44. By registered for the daily release. This the matter of notice is also issued on the interim. EPO.
It's my actually, can I do all the stuff you have on 2021? My lord, I submitted and by bid and my bid was accepted. And by on 29/7/2021, a notice was issued to proceed with the work. But Lord, my
Minority dated
12/1/2021. Then my lord, notice of proceed with the work was issued on 29/7/2021.
yes, then
So my at the time when the work were executing my work, this is the construction of a footpath, concrete. So my footpath, my lord, on the side of both sides of the road, allows a drain. So my lord, what actually happened? My lord, at the time of my lord, the initiation of the entire project, my lord, then there is no demarcation made by the civil authority because some land was belonging to public, some land belongs to private. So my lord will find on 26/7/2001, PW department is the executive authority wrote to my lord the district commission.
26/7/20
26/7/2021.
notice to proceed was given after that.
Yes, my lord. After that, because they understood that demarcation has to be done.
Representation given to
On my lord, a letter was issued by the PWT, the government, deputy commissioner on 26/7/2021, my lord. That said, my lord, is to take step to demarcate PWT road on the both side of the Vivekananda road. That is the road, my lord, so that the work can be started. That my lord will find it page 54. And that is it is the where my lord, the whole problem will start from that date, my lord. Page 54, Lord will see.
yes.
My lord is one.
Yes, yes.
Then my lord will see page my lord 49, my lord 29, 21, my lord, that page 50. Next, and next.
825.
Yes, my page 55.
So where did you get the date?
My lord, it is only my lord. This number 55, my lord. I requested the authority. Page 55.
Where is the
My-
date?
Page, my letter. Page 55. And it's
Where is the date?
date received, my lord, on 4/9/2020, below my lord. That is the date on the receipt, 4/9/2020. Then lordship will kindly see, my lord, page 57. Because for the purpose of demarcation, that map of that particular locality is
Okay, then what happened?
Then, my lord, page 58, lordship will find that, my lord, this is a letter written by the settlement officer to the deputy commissioner to provide them with a map.
Look, are you going to go through each and every page? Or
No,
what?
my lord. Then I said, his demarcation is yet to be complete. That my lord will find, I just take only the last letter. That my lord will find at page, my lord, page, my lord, 106, my lord, you will find. First lord, page 106. And see, from that date it is going on. Page 106. In connection with that last paragraph, you are requested to kindly take necessary action to expel the demarcation and, my lord, the eviction of encroachment. So what I just submit, my lord, that this road is comprised of private and both public road. So they have to demarcate because public is not allowing without any demarcation. Now next page, my lord, will find at page 108. Sorry, my lord, 107. Yes. Now, 107, or after that, my lord, a survey team was deployed. They carried out the survey, but no finalization was done. Was not the situation, my lord, the what cannot be worked. One side of the road was, my lord, made available to me to the extent of 80%. I completed what 50%. So far, the left side of the road is concerned, my lord, 30% work as per my instruction we have completed much. So for 20% what of the right side is concerned, that cannot be completed, my lord, because that they have to remove that transformer. Transformer is stored. Again, APW department have been writing to APDCL. They are not doing anything. So, my lord, now lordship will kindly see page 111. That is the imperial letter, my lord, which I, my lord, told you. Page 111. Yes. Now, lordship will find this is a letter to the executive engineer from the chief engineer. Lordship will, may I read lordship? In inviting a reference to the above, you are directed to conclude the work. Because the sales scheme was sanctioned in 2021 and consider time is already elapsed, you to delay in demarcation and public document. So demarcation is their part of performance. Clearing up encroachment is their part of performance. So therefore, close the contract. I have already completed 80% of the work. And my lord, and lordship will find therefore you are
80% only for the right side of the.
okay.
Yeah, only for right side, only for the right side.
Right side. And other side, because of this, they could not make it improvement free. They cannot demarcate. I have seen you up to 2021 March. Till then, they have to clear, make the demarcation.
They cannot do it, so what to do?
Now, my lord, my problem is this, lordship will send this in next paragraph. Therefore, you are directed to submit a final bill in this respect, and a fresh balance work estimate may be prepared and reserved for the for honor submission for the necessary sanction. So what I have done that, my lord, now they are going to place another NIT because of their failure, my lord. So that my question is, though I am not responsible, my lord. So let them up to restructure life. What has to be done?
No,
You
no,
want to buy me or buy other, my lord.
they are different aspects.
Yes.
Maybe you see they're not the public, they want compensation, higher compensation.
So
There-
let
there
them,
are many-
what I respectfully said, madam, I'm willing to do the work.
No, no,
Let
are you willing to do the work as per your 21 rate?
My lord, their clause says, my lord, there is no provision of escalation. So, my lord, let them have a discussion, joint discussion on the, I am available for discussion, my lord. Let them have a discussion, let them obtain instruction, what to do. My lord.
Yes, when we talk about this issue order, we need a presentation. Based on the penalty. Because of my lot, they don't have to go present the wall, it has not been deep.
It is process issue.
It is our fault, my lot, because of the land, my lot, inside. So it has been my lot, taken.
So they
Not
have,
as a court
now,
process.
if my line of friends said that they're not going to do anything, so about balance is concerned, then that is an issue. Like, but if they, my lord, wants to start the work, complete the work,
So he can participate, the rate will be
my
different.
lord, then my lord,
That,
that I'm saying, my lord, they may issue that at my cost. If they go for it, they let them obtain instruction, to do that, my lord. I am ready to do the work. Then,
what you see, my lot, what the executive engineer is asking the executive engineer to give the estimate now. Probably it will
Take
take time,
estimate.
yeah, it will take time to have procure the kind of less part of the land man for construction. Only thereafter, when the tender will be issued.
and my that's not, my
For
lord,
the
Just a minute. Let me hear the other side. It did not disturb you.
So my humble submission, my suppose the player made the present inspector to allow him to work. How can he work, my lord, when the land here property available for again it will take time. And already, my lord, he has started giving my lord demand representation for my lord escalating the price.
Where is that?
Yeah.
That's what I said.
Yes,
You want that or is that? That's what.
95.
Huh?
Page 95
95?
of the this is the representation. And my lord, again, my lord, the legal notice was also issued on January 25 in page, my lord.
Yes, where is that? Yes. At the bottom, page 95.
And my lord, page 100 lot 53 part of the. The 96 of the.
Just a minute. You are requested to revive a revised working estimate. Considering the market rate increasing day by day. Your submission just now.
Yeah.
And your representation doesn't match.
my lord, your shipment kindly pays 1 1. Why am submit on submit? I am making submission on the on basis of that now. Page 103, not to be seen. In the contract agreement of the work. Well, it was number 47 was delayed. And there is no price extension clause due to delay completion. There is a communication, Mala, the chief engineer by the executive.
No, that is one. But then prior to that, your period notice is there, your representation is there.
My lord,
You see, you cannot make submissions in black and white. You have got to be either black or you have got to be white. You cannot say that I don't want to eat breakfast, but on the other hand, you are shouting, "Where is my breakfast?" That cannot be
said,
done.
my lord, I am willing to do the work. Let them have a discussion.
So the answer is there in page 103. Because of anything. Here, my lord,
I
it's
said
stated,
because my
there
lord,
is no clause in the
no
contract
substance.
for price escalation.
Then,
So
then,
we are bound by the contract. We cannot, my lord, my lord, now enhance the price without there being a clause in the contract. That has been provided. That's why we are.
What is wrong? What is wrong? Sometimes it happens that contracts cannot be completed due to various reasons. Now,
well, whether they are going to execute the work or they are going to abandon the project. Then,
they will decide. That is not your concern.
that is why my lord,
Their only concern is that you should be given your work for work done. You should be given.
I have given a financial representation that I am willing to do the work.
Mr. Council, that is only your written thing. There is nothing in writing. In writing, yeah, everything is the other way. In writing, you are saying you want cost escalation. But before this court, you are saying this now that let your petitioner file a affidavit saying that he will abide, he will do the rest of the work as per the rates given by him in 2021. If you can do that, that's good enough.
Your Lordship, my file is 100.
No, you just give an affidavit. That is your case. If your case is that you can do the work as per the rates provided in 2021, okay, then we'll consider your case. That is what you have said. That is what you have said. You cannot go, you cannot blow hot and cold at the same time, right?
Lordship, 113 page, my family. Then it is my report. Then my family, my lord.
I will record your statement and I want a affidavit from you. That's all.
My lord, I have not said that, my lord, it is the letter, but they refused it. So it is not my demand.
Look, please. Yeah. Yes.
I have not said, my lord, that it is the petitioner said that my rate should be escalated. They said escalation is not permissible. This is the statement.
Right. Heard, Mr. Where is your Vakaragama? Huh? Is there? But where is the Vakaragama? Is there Vakaragama your side? Heard, Mr. Bijapur. Then talk for the petition. To submit that the petitioner has been selected for reconstruction of Vivekananda Road and drain sub footpath, including box shelf convert, bracket from BC College to India Club Point, bracket road, of CH 0.00 to 2200.00x under package number SOPD -D -20 -21 for the year 2021. Pursuant to DNIT dated 12/1/2021. The petitioner was issued notice to proceed with the work on 29/7/2021. And accordingly, the petitioner proceeded with the construction process. Thereafter, several interdepartmental correspondences were made between the PWRD and the district administration for demarcation and eviction of encroachers from PWD land, so that the contract work could go on smoothly. However, the where is the impugned order?
Page 111.
However, write the impugned letter dated 4/4/2025 issued by the Chief Engineer PWRD to the Executive Engineer PWRD Silchar and Udarbond Territorial Road Division. Comma. The contract work given to the petitioner is to be foreclosed, and as the same has not been completed due to the delay in demarcation and public objection with the contract work. Write the impugned letter dated 4/4/2025. The Executive Engineer PWRD has been directed to submit the incomplete final bid of the petitioner for sanction of the amount. Further, the Executive Engineer PWD is directed to make a fresh balanced work estimate as desired by the local public for onward submission to the government for necessary factors, and to explore the possibility of completing the remaining works. No. Wait, sorry, cut that. Whatever I said, just read from the beginning. No, read from the beginning. Oh, no, it's not from the beginning, that last paragraph. Complete final bill, incomplete final bill, and a fresh balanced work estimate as desired by the local public for onward submission to the government for necessary fact. Further, the executive engineer PWRD has been asked to explore the possibility of completing the remaining work. Next one. The petitioners found the subject that the non-completion of the contract work has been occasioned due to the inability of the respondents to demarcate, to make a demarcation and to remove the encroachers who are objecting to the contract work. He submits that some portions of the land on which the petitioner is to work belong to the public and private party. He submits that the petitioner has completed 80% on the right side of the road, while 30% of the work has been completed on the left side of the road. The petitioner submits that the petitioner is willing to complete the work, to complete the contract work without any revision of rate. That is in terms of the rates quoted by him in 2021. Correct? That is the submission. That is,
No.
we can, it is live streaming. We can always rewind and see what is there.
Some parts, my lord, I'm unable to make it, you know. What I submitted, my lord, that my language pointed out that he make a replacement connection. So I said, my lord, under my letter, at page 1 thing, department said this commission is not permissible. My lord, if he is willing to go on that, let me obtain an instruction on that issue. On that.
Okay, now you have changed your mind. Okay, right. That's very good. At least now I know where you stand. Whatever I said, the petitioner's counsel submits that the petitioner is unwilling to do the contract work at the earlier rate quoted by him in 2021, and that due to a flux of time, he is willing to complete the work as per the revised estimate by revising the rate. Okay. That is best. Good stuff. Next paragraph. Mr. B. Over, the learned counsel, the learned additional AG, but that's how. Submits that the submit that as the contract work could not be completed due to public opposition to the contract work, the state government has taken a decision to pay to the petitioner the pay to the petitioner his bills for the works completed by. It happens that as and when there is a possibility of completing the work in the future, a fresh NIT would be issued at the revised rate, and the petitioner would be also allowed to participate in the selection pool. What remains?
My lord, submitted, then that may be my lord, they consider.
My solution will be that not party complaint, yet to demarcate and eviction.
You said due to non-completion of the demarcation
And eviction of.
and eviction of encroachment.
So my lord, I have. applied for
Instead of
extension
public
up to
complaint.
39 months. I applied for extension. It was granted up to 31st May 2025. That also letter issued month. I applied up to 3 months. That may be considered month. My representation. That may be considered by the department. That means under the, let them have a considered month. If some possibility.
We also submit the additional AG first copy. That the prayer of the petitioner for price escalation cannot be accepted as there is no clause in the conditions of contract agreement signed between the parties for price escalation due to delay in completion of the project. Yes, so what needs to be done? So you want them to dispose of your.
My lord, finally,
They're not handled. Because whether you want to complete the work in the escalated price.
my lord, let them have a describe my final representation. Let-
You think, yeah?
My-
Foreclosed it. Now, what is the question of settlement debt?
My lord, they may, my lord, because there is a decision of apex book, when there is a lack of performance on the other side. Because
Is there any alternative remedy available?
Not to keep that matter, I think you got to claim any damage.
No, my,
Correct. There is a Supreme Court decision that you can claim damage.
no, my lord, not on the damage. I said my lord, Supreme Court enunciated that in this particular.
I don't know, I don't believe you now. Because next day, tomorrow you say, or later you say, I did not pay them. I don't know.
There's a
You, yeah,
representation
you can change your color like a
No,
chameleon
my
so
lord, not-
fast. I heard you for around 5 minutes saying that you will do it as per the 21 days.
What explain to my lord, Paresh, I was unable to, my lord, my lord, to convey my lord. They say escalation, they say there is no escalation, that I want to put my notice on my lord. So my lord, I because then let me, my lord, discuss this matter again. But I can face a decision of the epic.
You can say this, he can say decision with regard to damage.
Proximity page 114, whether there is last representation.
Yeah.
What is just page 114. However, I again request your honor to exert your helping hand for
Yes.
completion of the package within the tender agreement and POQ.
Yeah,
Thus,
tender
to
agreement.
utilize the large quantity of steel for the window. But if you get them in my lord.
My tender agreement, I said I tender agreement. So this may they will consider my. So going for project is helping nothing, nobody money, not helping them.
You
no
take a
helping
decision
the
on his
party.
representation, how does it help?
Yeah.
I'm not going to give any stay or anything. I'll dispose of the entire repetition.
Well, they may dispose of my report, they may dispose of my report. My lord. Some way, yeah.
But it will be given to us, but if you want, we will consider it. Otherwise, in the repetition, nothing is there.
Correct. Okay, right. Okay, I've heard the last thoughts for the part. Okay, before that, the petitioner's counsel submit at this stage that the petitioner submitted a representation dated
What, dated
11/4/25 to the respondent number
respondent number, my lord, executive engineer.
6.
6.
saying that the petitioner should be allowed to complete the contract work. As the same has not been completed and as the same has not been decided, the writ petition may be disposed of with a directive to the respondent number 6 to take a decision on the petitioner's representation. Dated 11/4/2020. I have heard the 11th part. On considering the prayer of the petitioner's counsel that there is petition to dispose of, can be disposed of by giving a directive to the respondent number six to take a decision on the petitioner's representation to 2025 from this court directly. And this court accordingly directs the respondent number six to take a decision on the petitioner's representation within a period of 2 weeks from the date of receipt of a certified copy. This petition is accordingly disposed.
Only thing is they're making objection on the basis of.
I have not said anything. I have not said one. I have not made any observations. I have not made any findings. Only his submission and your submission. Huh?
Consider it on the phone.
To consider the same as per this question. As per this question.
May please note, pilot, item is related to pilot, the non-payment of contractual fee.
Huh?
Non-payment of contractual fee. And it's 60 page mail page 58.
Okay. Wait a minute. Right, third, Mr. Arrest on the counsel for the petition for subject that the petition is not repaid. His bills amounting to rupees 21,96,327 for supply of articles. Issue notice referable in 4 weeks. Mr. S.R. Barwa, accepts notice on behalf of
Response number 14567.
Mr. B. Gogoi for 12. This is a matter of the full.
Extra copies.
Extra copy.
After 2000.
Huh?
This case was listed after 2019. Well, sometime.
The problem is, this court has already passed an order in earlier repeating. And decision has been taken by the, yeah, for the APDC as well. Now, what is to be done?
Whether they are both are not up to the satisfactory of the, that is what I think. I need to take, I need some time, one thing for the application. So I can.
Look, no, what I'm saying is that we are disputing question of fact that can the lead court decide? As no one appears for the petition on. The petitioner had earlier, now, while Mr. A. Rompi, what is the name?
Peter.
Peter appeals for APDC. The petitioner had approached this court earlier by way of WPC number 5985 of 2014. Challenging the rejection of the petitioner's claim for payment of contractual fees. So, WPC 5985 of 2014 was disposed of by an order dated 12/5/2017 by giving opportunity to the petitioner to submit a detailed representation before the respondent number 3 to consider and take a decision on the petitioner's representation by passing the speaking order. The respondent number 3 thereafter issued the improved speaking order dated 6/9/2017, rejecting the petitioner's representation. By holding that the petitioner was unable to substantiate his claim with any documentary evidence. uh, Among other reasons. The petitioner's prayer for review of the impugned speaking order dated 6/9/2017 was also rejected, while letter dated 18/11/2007 issued by the respondent. On considering all the above, no, put some, next one. This court had sent the matter for mediation on 6/8/2018. However, as per the report of the mediator dated 13/9/2018, the petitioner did not appear in the mediation, and the APDCL had stated that it was not willing to settle the dispute in mediation. This one. On considering the speaking order dated 16/9/2000, there appears to be disputed questions of fact. However, without disposing of the repetition, the matter be listed again after 4 weeks in the interest of the. No one appears for the party. This is the matter. After 4 weeks. Your embankments are still stuck.
Madam, there is a specific order by the Honorable Court, Madam. Last petition you want to go through it, Madam, Madam, third paragraph. Order dated, Madam, 10/4/2025, Madam.
Yes.
10/4/2025.
Yes, what about it? Yes, I've got it.
Yes, Madam. The Honorable Court directed, my lord, they have to complete the process, my lord, to within specific time. Madam. Check. Third paragraph, Madam.
Yes.
Although the government has filed an affidavit where there is a clear averment that the decision has taken by the authorities to remove the embarkment ban, but because of obstruction by local people, the same could not be carried out. Learned government advocate is unable to apprise the court as to what steps are taken at present to remove embarkment ban in terms of the decision taken by the authorities. Under such circumstances, the court directs the state respondent to complete her instructions and apprise the court
as to the steps required to be taken and or taken by the Deputy Commissioner Sunitpur with regard to the removal of the embankment. But they did not speak to the difficult.
Let us wait for them to say. Let them say, if you carry on saying without giving them a chance to speak, we will not know anything.
Or if directed 15 days time to complete
Already there, how many times will be there?
the.
This election was there earlier also. You see what happened? What happens if you have got 200, 300, 400 villagers out there stopping you? What can you do? You fight with them. What to do?
After the fund is taken by the forest department, they also think that they're going to be formed. But in the government property matter, I am taking on.
Let us see, let us see. You see, for whatever loss you make, you can always file damage.
Not only
For
that,
you, it's only money.
because of
For you, it's only profit. From 100, it's going down to maybe 0 or 20. So that you get things.
society.
Yours is only money.
Of the fishery.
Your issue is only money. Anyway, they have to take any time.
But time, my lord.
Yes. When? When? Correct. And you see, now is election time.
Right.
They will not do anything to lose their votes.
One problem is that this order is only given the Deputy Commissioner Sunitpur, but not given the Vishwanath. Sunitpur as well as Vishwanath, that may be. Sunitpur and Vishwanath.
Okay, right. Mr. K. Gogoi, Senate Council for the state government submits that we need more time to give it, to obtain instructions in view of the fact that the panchayat elections are going on at this. In view of the prayer made by Mr. K. Gogoi, this court directs the state respondents to complete their instructions and applies the court as to the steps required to be taken and taken by the Deputy Commissioner Sonitpur and Deputy Commissioner Vishwanath with regard to the removal of the embankment bracket fund. This is the matter of the. Give it. We have also written the authority of clear not to no, why you adjourning the matter all the time? Yes. Last president of my civil brother is just one letter of the regarding the negotiation of the payment to the scheduled to be held on 28 March. Now it's not even 1 month away. It's now we're in May. No, just tell me one thing. Even if there is inspection, what are you going to, in the meeting that is going to be held, what do you expect the government to say? Huh?
Is that there was some excess work done over and above the budgetary approval. It was done without approval of the finance approval. So the department has now sent the proposal, export picture approval to the government body.
That has to be given exposed to all the department will have to check out, will take it from their income.
So that response from the Home Political Department.
So also the picture of the 10 days which in the Otherwise, they take the fair plan of work.
They have to be given the amount. Whatever approval ex post factor has to be given, has to be given. Nothing will happen within 10 days, Mr. Pala. Nothing will happen.
Come up with some.
You come up with some definite proposal. It is, otherwise, no point there.
Most of the questions we have filed application here, it was the one that we will file the application action by. There is no dispute.
There's no dispute with regard to what.
Regarding their excess work done by them. Beyond the budgetary provision. Watching a
This election counting is when? 11.
I don't know, specifically after 10 days or 15 days, person enough time, okay.
We'll list it on, say, 22nd. Twenty second. Tell them. That 10 days. Right. Mr. Take over. Then a council for the state respondent. Pray for 10 days time to obtain his practice as. No, with regard to the outcome of the meeting, correct? No, that is only a document.
So there is also a proposal.
For that report factor. That means that, within 10 days time to obtain the outcome of the meeting held on 28th 2020. And the ex post facto sanction to be given to the work done by the petitioners beyond the contract estimate. This is the matter on 22nd. We keep it as partner. This one. I mean, as we first partner, huh? Partner. Partner. No one appears for the petition on call. Why is Mr. G. Bokalian? Mr. G. Bokalian appears for all the response. The petition is aggrieved by the order dated 2024. 22/1/24. By which the petitioner's fair price of license has been cancelled. This court has observed on the last court date that the petitioner's counsel should obtain instructions as to why he could not avail the alternative remedy available. In terms of Article Order 29 of the Assam Public Distribution of Articles Order 19. So, however, no one appears for the petitioner of the matter is not thereby giving right to an inference that the petitioner is not interested in pursuing the matter. That this petitioner is following the dismissed for non-pursuit. Huh? Who is for the finance department? Finance department is the party here, madam. What to do?
Yeah.
No, you see, the problem is the proposal has been sent to the finance department. Now you have not made finance department a party. Without them being made a party, it is very hard for this court to help you. Otherwise, you will feed them here. Right. Miss D. Bora, non-standing counsel for the Medical Education and Research Department, has submitted letter number MER-16/2024/34, dated 3/5/25, issued by the Undersecretary to the Government of Assam, Medical Education and Research Department, which is to the effect that the proposal of financial sanction amounting to rupees 22.25279 lakh bracket MS Godrej and Boys has been resubmitted to the finance bracket EC dash Roman C bracket to department on 30/04/2025 for concurrence. However, till date, concurrence has not been received from the finance EC dash C department. The letter also states that the financial sanction that funds will be released through fixation of ceiling once financial sanctions will receive from the finance bracket PC dash Roman Things Department. So basically, once that is given, we will give things. So we can dispose it out there. Then you write one thing. Before this, just write third, Miss
Veto.
D. Chaudhary, counsel for the petitioner. Ms. D. Bora appeals for appeals for the Medical Education and Research Department. Then you are for madam? Ms. Yani A. Sharma appeals for the appeals for fund number. The petitioner's grievance in this petition is that he has not been given a supply bill amounting to rupees 20. No, amounting to rupees how much? 22.
No, Roshan. Comma 790
You see,
Now, for Godrej and Boys. For Godrej
got
and
two.
Boys.
That's what. So it's altogether 22.
22.
That's what I'm saying. It is supply bill amounting to rupees 22,25279 lakh. Bracket, yeah, bracket is bold figure. Till date. For supply of for supply and installation of hospital furniture for Jorhat Medical College Hospital, Jorhat. Miss D. Bora, submitted that which I gave you. Next time. Then on considering the fact that the amount claimed by the petitioner is an admitted amount, and that the non-payment of the same is due to the inaction of the finance department in not giving concurrence to the proposal submitted by the medical education and research department of this court is of the view that the commissioner and secretary to the government of Assam finance department should be impeded as respondent number 6. Accordingly, the commissioner and secretary to the government of Assam finance department is impeded as respondent number 6. Issue notice is correct to the respondent number 6. Mr. M. Puya accept notice on behalf of the respondent number 6. Extra copies of the writ petition be provided to Mr. M. Puya during the course of the day. To start. The petitioner's counsel shall also submit a corrected copy of the cost title to the registry within 2 days. Within 2 days. Full stop. Next para. I have heard the learned talk for the. The letter dated, so, 3rd, 5, 3, 5, 5, is made a part of the report and marked as an exhibit. The contents of the letter dated 3/5/2025 is reproduced herein below as follows. From here to here. Next. In view of the claim of the petitioner being an admitted fact by the Medical Education and Research Department. The and the proposal for payment of the same having been submitted to the finance department for giving financial thanks of this for direct the respondent, including the finance department, to give financial thanks to the said amount. To the said proposal. Thereafter, the fixation of ceiling should be made by the concerned department and payment made to the petitioner. The entire exercise should be concluded within a period of 4 months from the date of receipt of a certified copy of the fund. The writ petition is accordingly disposed of.
I need the item number 25.
Yes, there is an alternative remedy available. Why don't you take it?
I have to request my question.
I'm picking it up. I'll give me that item. Wait.
In the last petition, I know there is an order to report about the alternative remedy available. But they have got for alternative remedy, and I think on the cost, in the meantime, my lord, at that time, what happened? The appellate authority was, my lord, resolved by the, my lord, government by a cabinet. So, my lord, the divisional commissioners are concerned. Those two have to be resolved by the government. Thereafter, my lord, for some time, my lord, they have not, my lord, appointed any other person. Now they appointed commissioner and secretary to the government. We have applied for, filed appeal before the commissioner and secretary in the month of, my lord, July. That is still pending. I'll bring on the fourth.
No, so if you are fine, that's the end of the matter.
My lord,
So you cannot take recourse to two
my lord, what
parallel
happened, my lord,
proceedings.
what happened, my lord, they are not disposing of the appeal.
We direct that to dispose of. We direct the appellate authority to dispose of. You cannot have two parallel
Yes,
proceedings.
yes, my lord. For that, my lord, I'll bring on record that appeal only, so that lordship, your lordship can peruse the appeal.
No, I don't need. You just give me the appeal number. What is the appeal?
To take it up at two, you bring the appeal
Email
number.
number is not available, my lordship. Day after Monday, today is Monday, day after tomorrow. Then my lord, next day. Saturday.
I'll leave it, it is posed itself. You bring the number, yes, that's the post itself. You bring the number by today or tomorrow, we'll wait for that. If you don't give it by tomorrow, the order will.
By tomorrow, we'll give, my lord.
You give it to me, dispose.
Dispose matter with the direction to.
You can give it today also.
No,
You give it today, you just give
yes,
a call.
that I'll provide, my lord. They will dispose of the, my lord, appeal within a specific period.
Correct,
Yeah.
correct.
So they are thinking about the appeal, my lord, for a long time.
Maybe, but then you give me the appeal number, that's all.
By tomorrow, we'll give.
By today.
By tomorrow, I'll dispose. Well, I'll tell you. Yes, yes, I will inform today.
Either. So what? Petition number one is still there. Oh no, petition number one is still there. Oh no, you see, Mr. Council, you forget that. If you go to the merits of the case. What is your ground for challenge?
Okay, my ground for challenge is.
It is near the school.
Yes.
Now, what is the affidavit of the authority?
Yes, the authority says that it is outside the zone. What authority says one thing, they are relying upon a report.
Correct.
In that report, though my name, the name of my school is also there, but we were never asked to be present for.
How does it matter? If you go.
Conduct a fresh inquiry, that may be present and let's the next.
Well, just because you do, it's not to your liking what you do.
No, 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 because the inquiry report which we are relying upon, because that's behind my back.
Not behind your back, because due to somebody.
But then why did they believe me? Then I am talking them, then I should be the.
Because that person had brought you in there.
No, no.
Yes, yes. That was the case in the other petition.
We can.
In the other petition,
The other.
that person had said that it was within this, any distance from the school. So that is why so the report was made with regard to that school. And now, so that is being used here. What is wrong?
Because the other is there. I was not a part of the petition.
Maybe.
Petition.
When was the school, when was the shop established? Which year?
So, I'm.
Ah,
Other people of actually, they want the transfer of the job from one location.
correct. Yes.
Lord, respect the whole semester whether rented semester by other of the people, so they are going to. For the to rebate the benefit of it. And as regards the, even, letter they are saying the benefit were submitted. The earlier petition also the same representation was relied upon, which I have annexed at page number 15.
No. Just tell me your case once more. You're a school. You're established in 2017.
Yes.
Now you are saying that the petitioner shop, your shop is already there.
No.
It's going to be there.
Some other location.
It's going to come there.
We have already taken shift placed on rent, paying rent. So because of this petition, alert, we are not able to shift it there. The department is now that we have letting us shift. But the matter this petition.
So the issue is whether the distance of the shop from the said school as well as this, that is not your concern. It's basically the school. So it is within the prohibited limit. That's all.
The department has said that it's not over and both these two. Malad, the earlier exhibition of the lordship has matter on Malad. I have actually ordered at page 48. The same representation that they are trying to bring. This exhibition was like that. That
Let me page
Malad,
48.
page number 48 is your lordship's order. And at page number 51, your lordship will find this representation, which is also at page number 19 of the presentation. They are both the same representation on by the same school.
Okay. So this page 51.
Yes, sir. Was disposed of by this honorable court. The department was directed to conduct a fresh.
Yes, sir. Who is this Nikhil Roy?
Already, he was the petitioner in the earlier.
He had a white job. And on the, he submitted this page for page
Yes,
51.
Yes.
Nikhil Roy submitted.
yes, and this is the same annexure, which is also the annexure way of this current petition. Malad.
Okay, which is, on the
Under
page of which,
the both the representations are same.
okay, let me see page 48.
Page number 19 is the representation, which is same as page number 15.
Same, okay.
It was same, Malad, and the other petition also directed them to.
Okay,
conduct a fresh inquiry.
just get me. Just get me WPC number
41720.
417-2024. Disposed of on 29/1/24. So if this, you see your basis for objecting to the location of his shop is page 19. The basis for objecting to the location of the petitioner's, this respondent shop is page 19, correct? Now, so if page 19 has already been decided in an earlier writ petition,
Someone may have only 5 presentations, but is it different?
maybe, and with, general. No, sorry. Now, heard. Mr. M. Das, then it's also for the petition. Also heard Mr. A. Patra for this point number 5. Mr. R. Gugoi appears for 1, 2, and 4. Mr. S.R. Barwa for this point number 3. That's all. Right. The petitioner number 1 food. Now the petitioner number 1 is a school. Is a senior secondary school. And the petitioner number 2 is the principal. Was the principal of the state. The petitioner, having come to learn that the superintendent of Excise has submitted a report recommending the opening of a wine shop of the restaurant number 5 at a distance less than 150 meters from the said school, from the Alakpura Popular Senior Secondary School. Had objected to the same by filing a representation dated 18/1/2024. before the district commissioner, Dogri. However, nothing was done. The petitioner has filed the present writ petition, seeking a direction not to allow the shifting, opening of the IMFL offshore of the respondent number 5 school, point number 5, as the same is in violation of which rule?
Lordship 289, 294A, which provides for the restrictions as per 289
Violation of section
section.
290.
Rule Lordship 294A. You are saying that
Violation of 289.
289.
Rule 289.
Rule 289.
And
Rule 289 is
Rule 289 of the Excise Excise Rule 2000. 289 2, no? 289 2 and 2. Mr. Huh? Batra. Senate Council for the with point number 5. Submit that the basis for the filing of the submit that the representation dated 18/1/2024, which has been issued by the principal of the Alakpura Popular Senior Secondary School, which is the basis for the filing of the writ petition, had also been the basis for filing WPC 417 of 2024. Wherein the proposal to shift the IMFL off top of the requirement number 5 had also been kept.
Take a page 48.
Yes,
So if the basis for the writ petition was a letter dated 13/12/2023, not my letter. In that letter, at last it is requested, that if you are a particular people of that area, they requested, as such you are requested not to allow shifting of the shop in Alakpura area, so as to preserve the education and societal level. So they are acting upon that letter issued by principal in their letter. They are saying that because principal is. So our
anyway, that is his submit.
the letters are different.
He submit
Mine is 18/1 and
that
the other.
that the letter dated 18/1/2024, issued by the principal of Alakpura Popular Senior Secondary School, had been the basis of the letter dated 13/12/2023, submitted by the petitioner in WPC 417/2023 for challenging the proposal to shift the IMFL offshore of the respondent number 5 from Dubri town to Halakpura Bazaar under the Halakpura town. Next one. the council for the response number 5 submits that WPC 417 of 2024 was disposed of by order dated 29/1/2024 by directing the District Commissioner Dubri to examine the petitioner's representation dated 13th of 2023, which had been made on the basis of the letter dated 18/1/2024 issued by the principal of Alakpura Popular Senior Secondary. And this, and to dispose of the same thereafter. The council for the response number 5 subject that pursuant to the order dated 29/1/24 passed in WP 417 of 2020. The, where is that? Huh? The state government.
Page 34.
Huh? Page 34, writ petition.
We filed an affidavit. Oh, on what? Or you can turn to page 34.
Thirty-four is here.
34, 35, 35 is the report that you have.
34, huh? What about that? The, not state government, the circle officer, Agro Money Revenue Circle. Issue letter dated 22/2020. Which states that which states are found? Huh? From here to page 34. The council for the response number 5 subject that after perusal of the inquiry report and the letter dated 20/02/24 issued by the special officer Agro Money Revenue Service clearly shows that there has been no violation of rule 289 bracket. And that there is petition.
This inquiry was carried out, where the speaking order was already passed. Order clearly says.
Where is that?
It reflects that the distance of the high school was even considerable. Whole area is urban in nature.
So if it's urban in nature, what happened?
This criteria regarding this highway, like urban nature development.
But that the meters will apply, that one will apply,
And it's 160 meters away from the,
right? It's the RR over the land council for the excise department. And submitted order dated, what is it? 28 to
28 to
28/2/2024. Issued by the District Commissioner Office. With it to the effect that the proposed INFL off-top of the respondent number 5 in Halakpura Bazaar is beyond 150 meters from the Halakpura senior school. And as the place is urban in nature, urban in nature, comma. The it is exempted from the restrictive distance criteria as mentioned in order right number Roman 3/97/2015/16/176 dated 45/3/2000. We accordingly submit as the factor issue as to whether the proposed IMFL outcome of the petition of the respondent number 5 is within the 150, within the impermissible limit of 150 meters from the school has been decided in the negative, comma, correct, the negative.
Though they have submitted this,
The petition to the.
though they have submitted a complaint about the bunch of people come there. Another question is whether this school has an application or not. Yes, it is not because in the rule it says. The rule it says any school was always been coming up later on. I'm not about that. The education institution, what does education institution means? We have to consider something, it's rule 289 about. It says that education institution for the purpose of this rule means any primary school, middle school, high school recognized by the state government or central government or any college affiliated to any university established by law, but does not include any private coaching or tutoring.
So this is a private school.
They have not declared any they are
Private coaching or tutorial institution.
Where is the affiliation?
Coaching center.
Where is the affiliation?
School, the middle English school. Affiliated? Yes, sir.
Where is the affiliation?
I'm discussing your representative now. You can file appeal. Good. Next. I have heard the land talk for the. Rule 289. Bracket 2 of the Excise Rule 2016. Takes account. A perusal of the above rule shows that no IMFL off-shop can be established within a distance of 150 meters from an educational institution. Okay, go. Next time. The letter dated 20/02/2024 issued by the Circle Officer, Agomani Revenue Assessor, Agomani, clearly shows that the inquiry report that had been done to verify whether the respondent number 5 IMFL off-shop to be established in the Halakpura Bazaar was within 150 meters from the school. Showed that the step top was beyond 150 meters from the. The
order dated 28/2/2022, issued by the district commissioner, has also clearly stated that the IMFL off shop to be opened by the respondent number 5 is beyond 150 meters from the petitioners, and that it is it is located in an area which is but from us urban in nature. The order dated 28/2/2022 issued by the district commissioner will also be a part of the report and marked as an exhibit. In view of the fact that there has been a inquiry conducted by the state respondent, which has come to a finding that the distance of the petitioner's food is beyond 150 meters from the from the proposed IMFA shop to be established by the respondent number 5. This does not find any ground to exercise its discretion in the present case. The writ petition is accordingly dismissed. All right. So you filed it in July 2024, you said. So we dispose it out within how much? Within a month. Dispose it. But it has been issued to whom?
This letter was issued to my Lord Deputy Commissioner, Secretary,
So, but who is the appellate authority?
into my Commissioner and Secretary to the Government of Assam, Secretary to the Government of Assam, both Public Distribution, Consumer Affairs Department.
We say the appellate authority.
Yes. Our ground is that, my Lord, they have not supplied to us inquiry report. They have not, my Lord, supplied to us shopper notice. All these are not supplied. So,
Better that they dispose of everything that then becomes easier for us.
yes. Twenty times. They were just getting it. Just getting our affidavit. That's the type of problem.
To what effect? Infraction to what effect?
Yes, yes. Yes,
Infraction is oral or written?
no. That is the- So we'll put that in our affidavit. also. So I think the part.
Mr. Parva. Submit that instructions have been received, Lord. And he'll be filing affidavit within. Are you sure? We can take more time also. I will do file.
Can this be managed? Exactly 1 month, 1 year ago, my Lord, they have given time. Last order, if you want to go the last order. Just asking exactly
Okay, this is okay.
1 year ago. Exactly 1
This is the second time it has been listed after 1 year. Okay, is granted, yeah, is granted, yeah,
3 weeks.
3 weeks time. To file affidavit, the person list the matter and give a date. Good.
Check. Check. Develop. Instruction is awaited in the paper.
Instructions are waited. This is after how many? This is okay, this is not. So, Mr. S.R. Parva is granted up for the 3 weeks time to obtain instructions and file affidavit. This is the matter. How much time?
So, after
You received instruction?
they admitted amount that was
Okay, very good.
admitted amount, it's not taken.
Where is the instruction?
1,83,000 rupees, I admitted amount.
Okay.
So I got lost in the seven.
First, Mr. K. Sharma, Learned Counsel for the petitioner, who submits that the petitioner's contractual dues amounting to rupees 187,948 in respect of the allotted contractual work for construction of, this is here, huh? It is in the synopsis. Allotted contractual work. So here. mm, Has not been paid.
They got 7 lakhs.
It submits them. The total amount payable was 4,76,000. And the balance payable to the petitioner is rupees 2, no, 1,87,948. So stop. Next para. Mr. N. Upadhyay, the learned counsel for the irrigation department submit that the petitioner has already received rupees 2,88,052 out of the total bill value of 4,71,48. And the petitioner is to receive rupees 1,83,430 and not 1,87,94. I have heard, huh?
This is from the executive engineer, get the taking it verified.
Mr. N. Upadhyay submits that the instructions received by him, that the parawise comments received by him has been issued by the executive engineer, Stutia Division Irrigation System. I have heard the learned counsel. The parawise comment issued by the executive engineer, Stutia Division Irrigation is made a part of the report and marked as an Act. As the respondents have admitted that the petitioner is liable to be paid rupees 1,87,83,430 as per the parawise comments made by the executive engineer. This court is of the view that the re-verification should be done by the chief engineer, bracket respondent number 4, respondent number 3. In terms of the judgment of the full bench of this court in the case of Shamsher Ali and versus state of reported in 2008 for GLT1. Accordingly, the respondent number 4 and 3 can re-verify the claim of the petitioner and pay the admitted amount to the petitioner within a period of within a period of
So it is giving 4 months to all the 4 months, let it be 4 months.
within a period of 3 months from the date of receipt of a certified copy. Of like this petition according to. I don't remember what is the case. Yes, we did not submit the NOC.
There are co-partner and the also the co-partner has been submitted by the
Correct.
person who is
You are by the respondent number 5. Ferry service.
present.
So you are the highest. You're the highest.
I am the second time.
Second highest. You are the highest. But you did not submit your NOC.
From co-partner.
For the land valuation or for the non-encumbrance or what? For the land document.
land document.
For the land.
In our affidavit matter, we have stated in paragraph 6 matter. 6A, page 91.
Did I make any notes on this earlier? Did I make any sub? No.
Only directly to produce the document we are relying upon, exactly the appraisal. The uploads with the mother and the other, so affidavit filed by us, page 91, and everything to clear. A,
6A.
the petitioner stated that there is no NOP submitted by the co-partner. Regarding that, we have stated in 6A, page 91. Other. Nineteen people is standing in this.
What is the bid of the response? How much is the bid about?
$14 lakh.
Huh?
14 lakhs.
14 lakh,
Yes.
50,000. Okay, so now land valuation certificate of 26 bigha, 3 kathas, 9 letters. Out of this, 19 bighas is his land.
Private respondent.
What is it?
These documents are. Other.
So if 19 bighas, so that will cover 14 lakh.
Got it done. And the certificate of the company of it is there, second page, matter will be second page. Then we have annexed in our affidavit also, my lord, the second page also in my. It will be additional district commissioner revenue Morigaon. That number to
Just
call.
a minute. Just give me how many certificates, how many land documents? 3. Yes. No, the respondent.
There are so many documents. Different that number.
Certified the zonal value of land measuring 9 bighas, 3 kathas, 14 letters, covered by dam number 199424.
And totally an area of 19 bigha.
0 kathas, 0 letters. Usman Ali. Usman Ali is only this 19 kathas.
Yes, it's the requirement number 5.
Value that. These are all happening, but no idea.
I have marked whether the dark numbers.
Yes,
You know, time is the told second item.
page 23. Yes,
23 last year. Okay.
yes.
Next page, 24.
Yes,
If there are more than one partner, cannot be from the co-partner. But in this case, we have private customer, we have not get that. Over. Document start from this. Okay.
Your bid is higher.
He's the second guy to that, but
He the high.
He's the high, but I'm the really.
Where's the? Acha. No.
Point the point in this case, but only also from the one of the point.
That is not a prayer. Everywhere. That's not a stand taken in the repetition.
Yes, it is now prayer of praise your prayer. Because region my mother, paragraph 8. Yes. Region 9, my lord.
So that clause 16, so they are not pressing.
No, only from 16.
16, are you pressing?
Yes, ma'am. That's 8. Oh, close. Particular kind of page 24. I'm pressing. Page 24. Page 24 to start from 23. Page, page 23, start from page 24, bottom, plus 8. Okay. Then next page, page 24. Okay. If there are more than one patada, NOC from co-patada have to be submitted. The land documents and the land position of the documents. Now our statement of candidacy page 9. So paragraph 9. Page 11.
No, you cannot read page 24.
Yeah.
If there are more than one patadar,
Right.
NOC from co-patadar have to be submitted. The land documents and land valuation of a successful bidder against any ferry service will not be accepted if other ferry service the valuation does not cover the provision.
That is number one, the first line. Condition of it. Second thing, my dear, you'll have find page 29. Format. Yes. Format by the page 29. Let's see.
Yes.
It is in respect of that's 105. This format by the number 4 is land document. You also got it. Number 4.
Where
Page 29.
Yes.
Land documents including patta, land valuation, NOC of patta in the form of an affidavit duly signed by no. Not only NOC, ma'am, it must be in the form of affidavit. That's why simply report has come from ABC saying that pilot the land stands the name of the corresponding one. That cannot do, man. That will not satisfy the condition. It must be in the form of affidavit, must be notarized also. That has no way. Then in paragraph 8, 9, my lawyer was clear that you have to take the reply to that also, you can listen, madam. Page 9, paragraph 9, page 11. Page 11. Okay. That it may be mentioned here that apart from the above, the respondent 5 has not submitted the following documents with respect to police service to NOC from the co-patada. Then the documents were not self-attested, there was no barcode. From the above, it we feel that the tender was submitted by the respondent without proper document, with the absolute in those parameters of the term and condition of the tender in such a circumstance, the tender of the respondent 5 would not have been accepted, but been impressed by the respondent. Now, in the reply to that, you almost trying to see the affidavit page. Page 91. Reply to they have submitted. Yes, page 91, paragraph 6A. With regard to paragraph 9, in regard to the NOC from the co-partner, the official is writing. The respondent 5 has submitted land valuation certificate of an area of the land measuring 26 bigger, so and so, so and so.
out of this land, 19 bigha stands in his name and assessed at rupees so and so, as per Donald Guru and the so and so. That would not true. Less than in his name, but it must be in the form of affidavit. And this officer cannot say one. He is to say. That's what I is to say. I will not find anything. Officer is coming at my defendant. It itself shows my lord that something is there. It is all. Just take influence.
Warrant number 5 said he did not want to submit any evidence.
Last
On the last date, you said that.
I would get the ads early and there. Last order, the party, 4 2005. Same, but.
Correct. So you're taking the certificate not to file any evidence. So the requirement of the clause that the land radiation certificate for prices of land belonging to 2%. Correct. The requirement of NOC is protection of. So he in that land document, the petitioner is not the co-patadar is not the owner of the land. It's only petitioner's name is there. So I cannot read, that's the problem. I think what you do is you give a copy to the. What is the? You give a copy to them. Here, copy to some document. So I cannot receive that. आपने assembly बोला क्या provide a copy of the document that he has submitted today. To show that the land valuation certificate of the point number 5. Covers the security required for the bid. Covers the bid of the. This is the matter when. So what should. Probably all shipment. I don't know. Come wherever it comes. Further? The field man, very good. Okay. Okay, right. This is G for failure. Then counter for the response. If granted for further 3 weeks time to pay section and further to the matter. This is, I have thought my lord, they have filed the affidavit admitting. Okay, fine. May take up 34. Here, whole amount is indicated. 34, 34. 33, 34. 34, 34. 35 to all of 45. No, 45 to affidavit.
In 34 also there is affidavit.
Yes, but out of claim amount, out of claim amount, we have paid 2 lakh something. Paragraph 6, man. Everything is fine.
Four cases might not have it.
So para 6
Yes,
is admitted.
in item number
34
whole amount.
admitted. No. Okay, right. Heard Mr. Jay Barbuya, learned counsel for the petition. Also heard Mr. P. Bokale, learned counsel for the state respondent. The case of the petitioner is that he is the owner of various vehicles which were taken on hire by the respondent authority. However, the petitioner's vehicle hire charges amounting to rupees 35,33,581 as not reaching. Despite various representations made by the petitioner. Next, Mr. Dev Bokale, present counsel for the respondent subject that in terms of the affidavit opposition filed by the respondent number 7, the petitioner is the respondents are liable to pay to the petitioner the vehicle hire charges amounting to rupees 35,33,581. The bills for the vehicle hire charges have been forwarded to the Assam Police Headquarters, Gulubari, Guwahati, for necessary sanction and release of funds to be paid to the petitioner. I have heard the learned counsel for the in view of the fact that the affidavit of the respondent number 7 has clearly admitted that the petitioner is to be paid rupees 35,33,581 as vehicle hire charges. And the same, and as the proposal for payment of the same has been sent to the Assam Police Headquarters, Gulubari, for sanction and release of funds. That the respondent should complete the process for sanctioning the outstanding amount payable to the petitioner and paying the same within a period of 4 months from the date of receipt of a certified copy of the form. That is present accordingly.
And then I've also, my lord, paying my lord, out of 51, they have treated my lord 2,22,896 have been given.
How much? Total was how much?
Total was 51,34,441.
Yes.
They said 2,22,896 have been paid.
So how much is the balance?
Balance is my lord, page 95 BC.
95.
Yeah. 49 lakh 11.
95? There is no 95.
In the affidavit of it. Affidavit of it.
Oh,
94 and 90.
okay, right. Right, Mr. Jay Barbuya, very thoughtful for the petition. To submit that the petitioner's vehicles were hired by the respondent and the bill payable by the petition by the respondent amounted to rupees 51,34,44. However, the same has not been paid to the petitioner. Petition. Mr. P. Bokale, there is all the response. Subject that in terms of the affidavit filed by the respondent number 7, the petitioner was paid rupees 2,22,893 out of its total bill of rupees 51,34,44. Accordingly, the petitioner is still to be paid the balance amount of rupees 49,11,5. It submits that the bills of the petition have been sent to the Assam Police Headquarters, Gulubari, for necessary sanctions and release of. Entry of the admission made by the response that we are still liable due to the petition. The balance amount of the 49,11 of 5. After getting necessary sanctions and release of funds from the staff to the for direct the respondent to complete the exercise for obtaining sanctions from our funds and giving payment to the petition within the phase of 4 months. Applies. Sir, complete from Second, we have the order digit 17 to 25. Or 36. 17 to 22. Okay, the thing is, we have filed the complaint before the CBC. What is the outcome? Father outcome of the you are not.
It's a case of clear case of termination of contract. They failed to do the job. Contract was terminated, principally awarded to R7. He is making good progress. My instructions are that it is likely that it will be completed within 45. So he wants to stall the process by bringing it. There is an arbitration clause, man.
There is a stay.
There is no stay. Man. Bank guarantee has been stayed. Invocation.
And
of bank
guarantee has been paid by the court.
Yes. That is the difficulty.
How, huh? Yes. No, the matter is
There was an IA, my lord, in the IA, it has been stayed. my lord.
order of stay, without the bank guarantee,
Retapel is pending, my lord, that's a different issue, but because of the pendants, we have got a counter claim.
That's all, fellow.
Respecting.
What I understand is not. Public to my report comes within the year waiting for the city. Because this is the case one of a contract of 70 crore was given to the petition. He has completed the work for 40 crore. Then thereafter, my lord, he appointed respondent number 7 for doing the work at 20 crore. So in the meantime, they have. Who is appointed? Respondent number 7 is now appointed as new contractor at 70 crore. To do the balance work. 70 crore rupees. Whereas we have done it at 20 crore rupees to the same respondent. Because he is the domain expert in the subject. So we take 100 for laying down of 5. So it is not possible to do that. To complete the job within the stipulated time. They have given us a show cause. Anyway, look, let's cut to the tape. The thing is that we are not going to dispose it of today. Man, it is not ready. So, when do you want?
It is all right for me.
Okay, right. The council for the party felt that the matter may be discussed on 15. This is the matter of 15. In the meantime, KD Chaudhary, the deputy SDM, shall obtain the instructions with regard to the complaint before the CBC. Complaint that has been forwarded to the Ministry of Petroleum and Natural Gas, MOP, Ministry of Petroleum and Natural Gas. On 15, the status of the complaint. The status of whether they have started investigation or not started or something. This was
Because there may not be an inquiry, madam. Because in our affidavit, we have clearly explained everything, madam, whatever allegation he has made.
whatever.
We have explained everything.
How does it matter if he gets it good, if he doesn't get it good? It'll be good for either one of you. If he gets something, it'll be good for him. If he doesn't get something, it'll be good for you.
Regarding the inspection, but that I'm not saying anything. What is happened, we have got a counterclaim against him. Because of this, we have not initiated the arbitration process. That is why there is urgency on our part.
So 15,
15 months. We only pray, that at least an effort should be made to dispose of
an
the matter.
attempt can be made to dispose of the matter on 15.
Right.
Okay, you write their name. Mr. BD, Das appears for the petitioner. Mr. RP appears for
R7.
R7.
He's for R7, I am for 1, 2, 3, 4, and 5.
Mr.
MTech
appears for
1, 2, 3, 4, and 5.
1, 2, 3, 4, and 5. Mr. RKD Chaudhary for
6.
6. Anybody else? That way, yeah, submission of bills will be easier.
Contractual losses. Pending since 2022.
This is what? 15 of IMFL now. What is this? Item 37?
Non-payment of contractual bills will be pending since 2022. Now, I have contractual bills. So I have supplied unskilled laborers for facilitation. March 2025 case. So I am paying for some time. Already. What will take up after COVID? In the meantime,
Mr. P&S, Learned Counsel for the GMC, granted 4 weeks time to pay inspection and file affidavit. List the matter of the court.
yes. Those of the pending bills, I am still suffering.
We are lucky that we are hearing a case. We are not sending you to the civil court.
I know that I have, and I am of CS retail license. I got to a place, but then I applied for shifting sometime in 22nd of November. Now the jurisdiction excess inspector, he carried out inquiry. Every detail as required in the rule indicated and favorable report. That's on 25th. Now the jurisdictional district commissioner favorable reports for the shift. Ultimate is the commissioner. The commissioner, jurisdiction commissioner also that's the approval. I pay 2 lakh shifting fees as also for the current financial year, they are not operating. The 3 lakhs what I have paid. However, they're not allowing me to operate.
Who are not allowed?
The authorities itself. After granting the sanction, after all excise being done, all payments being made in last year and today. So 9th of January is the cutoff date when the commissioner of excise has granted the approval
9th of January of
this year. 22nd November last year, I applied for shifting. I paid my fees and all. 9th of January, ultimately, they granted approval and all tiers. It's not that only one. Excise inspector, district commissioner, and commissioner. So nothing else, no other authority is required to intervene on. I can understand it can be hard for them. On last occasion, it was taken me with the bar that some people are objective. Well, the NOC from locals was taken earlier, everything was short, and then the approval was granted. But if on this way or the other, if this proposition is to be accepted, then all one shop need to be closed. Someone can deliver objection. So not only they have hampered my business, but they are doing something against the law. The authority granting the proposal has to defend someone. They don't know what parameters they are excited with. If they may not be operating.
Also, page 20, commission of the approval. Asking the commissioner to issue the shifting order. So if the commissioner rather than stating that the complaint are being made. But the complaints are being, that's why the shifting order has not issued yet. The shifting order of the issues is their complaints are being made.
shifting orders to be issued by whom?
District commissioner. You have given the approval, but the commissioner has given the approval. So this is something that's good.
Complaints are being made by whom? Where is the complaint?
Because by the post of that particular.
Huh? Some branded person, creating nuisance and.
Who is creating this? Some drunken persons are creating. Naturally, what is wrong? There will be some person. You can't hold on them. That's not, nothing. This is a new case. Huh?
Committee approval. 25, it's at page 28. 28.
28 is by commissioner
Commissioner,
website.
site is the, nothing make one.
And then
That's the one.
That's the.
Earlier 25, that's the inspector's report, number 25. 25, I made the last paragraph, it's not 50 pieces. The last paragraph. The second last one. I've personally visited the proposed site of Srimati Susmita Saikya. I am off licensee and found that the area of the proposed site measuring about so and so on the ground floor of RCC building situated at Ganapuri Road, Pachodan, Rao, standing on the land covered by DAN number 158, included in PP number 15. In this regard, above mentioned licensee has submitted a copy of the license of IMFL and country spirit, copy of last year renewal challan, copy of an agreement of the proposed site, copy of Jamabandi, an up-to-date land revenue receipt, and site plan of the proposed site, duly signed by the junior engineer of Tinsukia Development Authority, copy of NOC from Bordori Gaon Panchayat, NOC from local people, copy of existing trade license, copy of electricity bill of new premises, etc. There is no education institution, public place of worship, and hospital with distance of 150 meters radius from the proposed site. Hence, as per Rule 294A2C2 of the Assam Excise 260, the shifting of the proposal of Mrs. Sushmita Saikya, IMFL off license from his existing site to a new site may be recommended if the authority pleases. That's after inquiry. Now, 27. 27 is the district commissioner. Who's tend to sit over his own approval. 27. So with reference to the subject above and in conformity with 294A of the Assam Excise 216, of the order to forward herewith the proposal submitted by Srimati Sushmita Saikya, wife of so-and-so, resident of so-and-so, praying for shifting of our licensed premises situated in Tinsukia Municipal Bond, Ward number 10, GMB Road, Tinsukia, to a new site at so-and-so, Rangangala Mausa, at the rented premises of Sri Mausa Borua.
So everything has been given.
Absolutely given.
So why don't we hear?
I am ready to shift. They are not allowing me to.
Who is not allowing you?
The XY coordinates of the.
Who has not allowed? Who is not
Both
allowing?
hands in gloves, Excise and the state will. Both hands in gloves. That's my case.
Huh?
We already given the approval to the district commissioner. We know the district commissioner saying that a complaint, that's why he's not allowing the shifting.
How can you?
Huh?
Huh?
All we want to say is that after the sanction was granted and approval was given, some people have lost their complaint. Maybe, but I have not yet opened. They take out everything out of me. They don't, they didn't not let me shift and open the place to not. Post sanction, they can't have. Behave that way.
Where is this area?
Please look at it. There's a requirement in law, it has to be within the same district, infra district, not directly. Or shifting. All requirements made met with everything. And I believe my colleague, Mr. Goswami, is appearing for the excise department, not for the state.
I'm here on something like that. Please complain. After sanction is granted, complaints cannot be made. Because in that case, all existing shops, everybody will go and file a complaint. Any complaint has to be examined or entered.
No, and the approval has not been set aside also, nothing has been.
It is seen when the sanction has already been granted. If that be so, there cannot be subsequent complaints. Complaints have to be entered in prior to grant of.
Correct. Third, Mr. S. Panik. Learned counsel for the petitioner.
Only thing, 294A, from there I am coming. 294.
What does it say?
It says, madam,
That book on page 170.
the shifting of premises license for wholesale or retail ban. 170, okay.
Yes.
The shifting of premises license for wholesale or retail ban of foreign liquor, country spirit and excise alcohol beverage from one location to another within the same district shall be allowed by the excise commissioner or the district collector as the case may be with the prior approval of the government.
And where's the prior approval of the government?
Here, so once approval is granted, thereafter, my lord, you see. Now, number two, the shifting of license premises shall be subject to fulfillment of the following conditions, namely, that the Gao Panchayat municipality town community concerned on both area, so and so, when is proposed to there has no objection. That the proposed premises are free from so and so. So NOC or my lord, any object are to be entered in prior to grant of title. Once sanction is granted, public complaint would not be entered in. Or else, my lord, every wine shop are to be closed, but everybody will come and file a complaint. I have seen, my lord, in most of the cases, these complaints are usually sponsored by his neighbor. There I have seen.
There is also
Last 10
technically
years,
one-
my lord, I have seen at least 90% cases, these complaints are basically, my lord, filed by somebody who is vitally interested.
My legal period is gone, you know, I could not even operate. They have realized it is. They realized, so 9th of January onwards, you know. Started. Of course, 22nd December and November to 9th of January, I will not have an upgrade.
With prior approval of the state government, what about the?
The entire exercise of shifting is done under 294A, and if the state government objects, the very proposal of looting, the thing that is aborted. So therefore, excise carried out with the approval of the state government. There is no engaging the fact that state government would not allow the shifting. Shifting has been allowed, but the opening is not being allowed.
Heard Mr. S. Panik, learned counsel for the petitioner. Also heard, should I put whose name? Your name or his name? Also heard Mr. R. Boy, learned standing counsel for the excise department. And Mr. G. Bokalian, learned counsel for the point number 12. The petitioner's grievance is that despite the respondent authorities having given their approval for shifting of the petitioner's IMFL of license from
And I'm just putting, IMFL off license and CS retail license. They're two.
in
IMFL off license 60/98 and country spirit.
of line 60 of 98 and country spirit retail of license number 46 by 2017 18. The from its existing site situated at located at ward number 10 GNB Road, Tilsupia, to a new site at Yelapupuri Road, Kachuk Jan Gao, Tilsupia. The respond authorities have apparently have not allowed the petitioner to shift due to alleged objections made by residents of the area. Post post the approval granted by the authority. Mr. R. Who is the learned counsel for the Excise Department, submits that once approval has been given by the authority, the authorities cannot stop the petitioner from transferring his location from one place to another within the same
within the same district
and operate.
and operate the same. This para, Mr. G. Bokalia, then it's started for the response number 20. Suffice that after approval had been given by the district commissioner and the commissioner of excise for transferring the off license of the petition, there was some objection raised by the residents of the neighborhood with their opening of a new IMFL shop. And as such, the shifting has been kept in abeyance by the district commission. Correct? After an inquiry had been conducted. How does it matter? Same thing. Inquiry says that only. So forget that after the inquiry. I have heard the learn talk for the. The fact of the case shows that the petitioner had applied for transfer of his IMFL on the transfer of his wine shop from from TMP Ward number 10 GNP Road to the new location at tab number 158, PP number 15, located at Gelapupuri Road, Tachum Jan, Town, Muza, Ranga Gora. The inspector of excise seems to be a Sada and recommended the shifting of the petitioner's wine shop to the new site. As per the inquiry report, it is 3011. The district commissioner Tinsukia thereafter issued a letter dated 30/11/2024 to the commissioner of excise, SF, stating that the proposal for shifting the petitioner's wine shop had been recommended as there was nothing adverse found in the proposal for shifting the wine shop. Consequently, the commissioner of excise, SF, gave clearance for shifting, gave the approval for shifting the wine petitioner's wine shop by letter dated 9/1/2025. Subject to clearance of all outstanding liabilities by the petitioner. The petitioner subsequently cleared all his outstanding liabilities and paid the required fee of rupees 2 lakhs
2 lakhs was paid on 21st of November,
on 21/11/2020,
and the rest on 31st of March.
and the rest by 31st of March 2020.
That's 3 lakhs and
Next para. As can be seen from the the court record, the necessary permission for grant of for granting approval for shifting the petitioner's wine shop has been given by all the competent authorities. The petitioner also paid the required fee for it. However, the district commissioner has apparently not allowed the petitioner to shift to his new location because of some objection made by the residents of the neighborhood. once once approval has been given, the district commissioner should not have stopped the petitioner from relocating his wine shop, as there is nothing to show, unless there is something to show that the provisions of the Assam Excise Bill 2016 has been violated. The Assam Excise Act 2000 and the Excise Rules of 2015 have been violated. The petitioner has also not been given any of any document by the district commissioner to show the written objection apparently submitted by residents of the neighborhood against the proposed establishment of the petitioner's wine shop, which the petitioner would have replied to if he was given copies of it. Further, it is not understood as to why only the petitioner's wine shop is being targeted when there are already two other wine shops. There's already one other wine shop existing in the area. The above being said, due to the fact that approval has already been given to the petitioner for location transfer of his wine shop, and as the same is not in violation of the Assam Excise Act of 2000 and Assam Excise Rules of 2015. The respondents are directed not to restrain the petition from his wine shop from to strength
And operate, and allowed to operate for 2 years.
and allowed to operate the same for the regulations accordingly allowed.
Four cases were 39 to 42. There were four cases number 5. It pertains to transportation of bulk LPG by road from Assam and Meghalaya for 5 years. Petitioners for a lordship whether they own 12.5 metric tons of tankers of size, I think 12.5. And according to the tender notice,
12.5 metric ton.
our capacity is 12.5 metric ton. So according to the tender, initially, the group was 7 metric ton and above, up till 14 metric.
What was how much?
The group of intending bidder was classified as a one class number, from 7 metric ton to 14 metric.
7 metric tons to 14.
14 metric ton. And there was another group, it is beyond 14. We are not concerned with that. Now we are concerned with 7 metric ton up to 14 metric ton. In between, at 12.5 metric ton capacity, we are basically the petitioner of 12.5 metric ton. So now what has happened, after the tender process was initiated, the bid submission date started, they issued a provision now. Putting us in a bracket of 10%. That means anybody who has 12.5 metric tons of tanker, maximum 10% of the total requirement will be allocated to 12. And whereas for 7 metric ton, it is almost 80%. So that classification, that change of criteria was challenged. Now, in
the tender, there was no restraint.
Yes.
As to the number of 12.5 metric tons
Yes.
tanker that would be.
Nothing of that. So in fact,
So, but then that does not mean that it would be 100% or 90%.
it could be 100%.
It could be 9%.
Open for all. Now they have classified us into a category of 10%. 7 metric ton, 10.
This is what liquefied.
liquidity by petroleum gas, LPG. So I'm not on that matter. Now, what has happened during when the first people moved, our representation was pending because I expect to be decided. They decided with something. Now they file an affidavit. That if Milo produces the affidavit. My IOCL was filed on 34/2025. Paragraph 8 is there, and I'm reading my law. Page 173. Paragraph 8. That with regard to the statements made in paragraph 8 and 10 of the writ petition, 10% capping does not present a structural change to the tender. Moreover, the petitioner's contention that it shall be out of work is false and misleading. Assuming is relevant, my lord, the petitioner has a fleet of 60 numbers of 12.5 metric ton. All these 12.5 metric ton TP means tankers, my lord, will get inducted in all his TP new vehicles, as all his TP are new vehicles and vehicles are inducted as per their age. The following table is inserted how all his TP tankers will get inducted. There are 3 places, my lord, Assam, Tripura, and Manipur. Assam, my lord, they say the number is 400. 40, the 10% comes to 23. Tripura 278 total number, it comes to 16, 10%. And Manipur 316, it comes to 20. So it seems, my lord, our all my lord tankers can be accommodated. Here, though we are concerned with in these cases Assam and Meghalaya and Assam, my lord, Tripura, Assam, Meghalaya, and Tripura. Now, my lord, if we participate in Manipur, my lord, our fee can be approved. If that is so, my lord, my only prayer before we launch will be, my lord, recording this kind of the
But there are 4 of them.
four. We are, I'm for the four.
So these 4 writ petitions are with regard to these 3 states only.
Yes, yes, sir. Yes. So now if we participate in Meghalaya, Mizoram, sorry, Manipur, my lord, perhaps my lord, our it will be accorded. Our only intention was.
How many have you got?
No, nothing. Total 4 writ petitions, my lord. 39, I will give that detail, my lord. In 39, 15 vehicles, my lord. In 39, I can 39. Item 40, my lord, vehicle 3. We have given the list of vehicles. 12. Item 40, 12 vehicles. Of then, my lord, only difference in 12 is that 3 vehicles are of 14.1. But the
3 vehicles are 14.1. But 14.1 is not an issue here.
12.5 and 14.5 in a cap.
Okay, they'll come under 10%.
And my lord, in item 41, 15 vehicles of all 12.5 metric. And last item, my lord. Last.
Forty-two. Already 42.
Okay. 13. So all our entire fleet can be accommodated. We participate.
55, it comes within 60.
Yes, that's why, my lord, if this submission of this my lord, statement of their definition is recorded by a lordship, just quote it and allow us to participate there. Will be highly obliged, will not present. With the court.
There's no point to think.
But certain level amount of uncertainty is still we have to participate in that. But still, I will take that.
Okay, right. Right. Mr. P.N. Goswami. Leonard, only his name. Or you want the name?
Along with capital.
And with the team for the Leonard copy for the petition. Mr. Okay, Chaudhary, for the Indian Oil Corporation Limited, assisted by Mr. M. Sharma. Yes, there also. No.
The petitioners are aggrieved by the change in the tender conditions by the respondent authorities in the NIT, in the notice inviting tender bracket NIT. 1/3/2025. Inviting bid for award of contract for transportation of bulk LPG
By road or
by
Assam
road
and
for the states of
Assam and Meghalaya
Assam and Meghalaya.
and Tripura.
Assam, Meghalaya and Tripura for a period of 5 years.
Right.
The case of the petitioners is that they are the owners of 12.5 metric ton tankers.
12.5 and 14 point, common order
12.5
and
and
14.1
14.1
metric.
metric ton tankers. And they had participated in the NIT. Huh?
So this is on-
Oh, and they were intending to participate in the tender for carrying the bulk LPG. Have you submitted or not? Okay. The last date of submission of the bid being we have, is 9/5/2020. However, in a pre-bid meeting that had been
Origin done there.
not pre-bid meeting.
How- After the pre-bid meeting.
That is what there was a pre-bid meeting.
Nothing to do with.
Okay, okay. Okay, how does it matter?
Exactly. There's no relation. Because of the operation.
But then how did it come to the public domain? It came in the public domain, how?
No, they participated.
But then, but is there any written resolution, anything regarding the meeting minute, pre-bid meeting minute?
That will not.
I remember one case you did just 2 days back, same. Where you said there's nothing written and you were, hammer at tongs and nothing, you cannot act upon it. There is nothing. Now you are on this side. Yeah.
Because
Okay, okay, okay.
origin term dated by 28/3/2005, day before.
Okay, however, white origin dated
28/3/2025.
28/3/2025.
Limited the scope of 12.5.
The IOC have limited the scope of
12.5.
use of 12.5 and 14.1 metric ton tankers
to 10%.
to 10% of the total number of vehicles to be used for transportation of the LPG. Next, Mr. P.N. Goswami submits that the same, the corrigendum would amount to changing the rules of the game after the rules of the game. That doesn't actually
Changing the basic criteria of the tender.
changing the basic criteria, the change of the tender. Submits that the corrigendum would have amounted to changing the basic criteria of the tender, thereby which would prejudice the petitioner. However, in view of para 8 of the affidavit in opposition filed by the respondent number 1 to 3, wherein it has been stated, wherein it has been provided that the 12.5 and 14.1 metric ton tankers of the petitioner would be included within the required fleet of vehicles for transportation of LPG. They would not like to press the writ petition. He submits that the petitioners in WPC 1932 of 2025 have 12.5 metric ton tankers and The petitioner is WPC 1934/2025 have 12.5 metric ton tankers and two 14.1 metric ton tankers. Correct? Four, not two, four, huh? Okay. So in that 1934/25, it will be eight 12.5 metric ton
Yes.
tankers and four 14.1 metric ton tankers. Okay, good stuff. In WPC 1935 of 2025, the petitioners have 15 10.5 metric ton tankers.
Yes.
And in WPC 1936/2025, the petitioners have 13 12.5 metric ton. Good stuff. Next up. What? Nothing new.
No, the last week petition.
You said you have 13.
13 mile, out of which mile 8, 12.5 and 5.14.
Okay, is that 1936? It will be 8
12.5 metric ton
12.5 metric ton tankers
and
and
5
5
14.
14.1 metric. Next. I have heard the name for the part. Para 8 of the affidavit of position filed by the respondents number 1 to 6 of 4. Para 8 is that time. Okay. In view of the fact that in view of the submission made by the counsel for the petitioner, the writ petition, what? Stand close.
Close.
Stand close.
Close will be a better order for me to contract there.
That's all. The writ petition stands close. We make it into one common order.
Yes.
Okay.
Thank you.
I thought it would take some time. Thank God.
My client take the right or the liberty.
That's
I'm liberty to find. Okay.
that's always there.
They're all the data to pay. Because one of them wants to bestow and part of the bestow being the license. They have calculated it. They have calculated. They have calculated.
14.1 metric ton tankers will be big, quite big.
So this stands a contradictory. In Assam, they say because of road condition, in Manipur, there is road condition. I suppose in Manipur will be better. Or better in Assam.
That's the reason.
Basically, one of premium giving many products, they out of the pressure it is the 7 metric ton tankers. Bracket is 80%. Most of the players in Assam are 7.
They have need to.
And the free operation.
New players and they'll come in big.
Yes. This is the beginning.
Dying big there. They'll take away all the business from this model.
Local one of
Huh?
I was thinking local and local.
Yes, yes.
All right.
Austin. Here it is. The end of the matter. That's what, yes, no, but you did not ask, neither did you. Both of you just kept quiet. Huh? He told you. Okay, right. Ms. S. Dasgupta, learned counsel for the petitioner, and Mr. P. Gogoi, learned counsel for the PWD, submit that the present writ petition can be closed inasmuch as the house rent payable to the petitioner has been paid. In view of the reinstatement of the writ petition statement. Yes,
Take place, like.
difficult. Difficult case,
Not difficult, but it's very clear.
really.
Yeah. The law is very clear that if somebody takes benefit out of a non-restricted debt, they must fulfill. That's the law. And not only quickly annex a judgment to coordinate them, but there is a line. And even section 70 of Indian Contract.
Tell me the work orders that are issued to you.
That's what on that point. That's on that point.
First, there was a work order, it was an emergency response. There was a flood situation, roads and everything was cut off.
Is there any admission by them?
Yes, there's admission by them. They've admitted that was, what was their stand, those some work was done, but there was no work order, that was their stand. So now only the point of law that whether without work order, some work is done, that is in admitted, without denying. Now whether,
What is the amount of work done? What is the amount admitted?
now amount, they have not admitted. Amount they have not, because there is no affidavit till now. In the last already case, there was a strict order that if they don't file affidavit by the next time, there will be doctrine of non-favors. Anyway, that I'm not pressing, I mean, they want to hear from both them. But the thing is that there was no work. Now, so therefore, there was no agreed price. Although
When was this work done?
work was done in 2017, immediately after the floods.
Mr. Roy, yes, what is your submission?
There is one paragraph comment. Of course, the trend is this kind of that, so far as the amount of work is concerned, pursuant to some request made by the deputy commissioner, the local government, probably.
That-
The deputy, so far as the record of the PWD is concerned, there is no such report that we are aware of.
So this is a party here.
I see, you ought to have made the, this to the final, otherwise, actually, do the make of the everything.
Is the DC a party here?
Yes, otherwise, the party does not.
Yes, yes.
Because PWD has got no role to play. Because the work that has been allotted to you, allegedly allotted to you, has been allotted by the DC. Is it? No, listen. Has been allotted by the DC or the PWD.
There was a joint inspection by the PWD as well as the DC.
Maybe, Mr. Council, my question is very simple. I am not asking for what you had for lunch. I'm asking what you had for breakfast.
Good.
So, who had given you the order to do the work?
What will be the minute of the district disaster management authority, which the DC was of course paid, page 49.
Yes.
If lordship sees the second paragraph, the deputy
Yes.
commissioner welcomed the members of the committee for input. Deputy commissioner stated that meetings have been convened mainly to recommend the schemes pertaining to infrastructure and housing and public properties that were damaged due to occurrence of recent waves of flood in the district. As per the government, as per SDRF, public NDRF, State Disaster Response Force and NDRF, norm for the year 1780. And thereafter, in the next page, Lordship will see. The executive engineer PWD has submitted a proposal in respect of 127 numbers of temporary restoration and 84 numbers of permanent restoration. The representative of MLA Hubli requested for immediate restoration of Halimari Bridge for better communication of the respective village. The executive engineer has PWD Rural Delivered PR Hubli assured to complete both the work within 3-4 days.
The problem, where does it show that you are the one who did it? Where is their admission?
They're admitting to some extent.
No, they are not admitting. They are not admitting that you did. He's saying that maybe you have done. Let us see. Just look at his paragraph.
Should we take a look?
No, let me see. You see, I don't mind. See, the thing is that for this court,
Yeah.
to pass some order, we have got to be clear. We cannot pass on speculation or why it might be. Was allotted to petition. Okay. Was DG Road was allotted to petition on the page. Okay.
So 20 years and working as a factor.
As per report, that was not, thank you. Where is this estimates that were not sanctioned? You bring it. I will direct them. Otherwise, you have admitted that he did the work.
But there is no work order now. What is the-
No work actually because of the emergency nature of the work. The thing is that why was this estimate?
Proposal was submitted.
Huh?
Whatever proposal was submitted on this for payment of the whatever. Then I think. Confident that no.
Not only that, why was the estimates not sanctioned? The reasons for not sanctioning. And the estimates also should be submitted.
Yes, let's go to item pending.
Give it a- No, but then let them bring, it is your estimate, you know, that's come from them.
Can you keep it as a part of the project?
I will file an application for it.
We don't know when he'll find out, right? The Mr. P. Roy has submitted. Has shown this court the Parawire's reply. Even issued by the executive engineer PWD, Dogri Civil Subdivision, which states that para 4 and 5 as follows. Huh? 4 and 5. A perusal of para 4 shows that the petitioner has been made to do the work on emergency bid and that the estimates that had been submitted to the higher authority had not been signed. In the affidavit to be filed by the PWD, the reason why the estimate that had been submitted to the estimate, the reason for not sanctioning the estimate submitted to the higher authority should be reflected. The estimates that had been submitted to the higher authority should also be annexed to the affidavit to be filed by the PWD. Mr. Roy submits that, P. Roy submits that he will file his affidavit within. Huh? Within 2 weeks. This is the matter. Yes, have you paid the remaining 25,000? If it, yes,
My lord, please, my lord, OM, my lord, their OM page number 35 of their affidavit. Page number 35 of the affidavit. The clause 4.
yes,
Clause 4, my lord,
yes,
below. An amount of rupees 50,000 only shall be paid to the persons engaged in election duty who receive non-grievous injuries from the firearm or any other weapon for a motor. So in my case, it is a non-grievous injury as per the my lord, respondents. My lord. We have
so have you received the 50,000?
no, my lord, 20,000 I have paid immediately.
No, no, you're supposed to pay 50.
My lord, can you see the direction in the main petition, my lord?
Huh?
Direction in the contempt petition. my lord.
Direction to person.
The writ petition, my lord, before the law. Para 9, para 9.
Para 9. Yes.
Say just and fair compensation to which the petitioner is entitled after receiving such direction.
Okay.
In this case, my lord, this injuries pertains to the concert election, my lord. And department has a notification which is related to Lok Sabha election, ballot is pointed out, my lord.
Okay, there was a look Sabha.
Lok Sabha, this is not pertaining to the panchayat.
Okay, where is
So
the
we don't
panchayat?
have any OM.
Where is the panchayat election? Where is the
No, my lord, the memorandum itself says,
page 35?
35 of my application, my lord.
Just a minute.
Okay.
This is Lok Sabha. Okay, this is Lok Sabha.
So for
And you,
considering this, my lord, after the discussion with the department members, a proposal has been made in respect of clause 4 to give for 50,000 to the petitioner. And here is the department is Panchayat and Rural Development matter. He neither the Panchayat nor the finance is a party here, madam.
Oh.
So my difficulty on my part is, sir, returning this amount, approval has to be accorded from the Panchayat department. And accordingly, just reduce to the 25,000 miles, and accordingly, that 25,000 has already been deposited in his account.
Where is your affidavit? Affidavit of?
Respondent number 2, ma'am. And logic may reduce our earlier instruction that is given.
No, where is your affidavit?
Respondent number 2.
I have got the affidavit of,
Only one affidavit. I have 5. Respondent number.
this is affidavit on behalf of respondent number 2.
2, ma'am.
That is you.
Yes. That is the deputy commissioner, my humble submission as per his access, he has done the exercise as per direction by the honorable
No,
supervisor.
show me that poem that you talked about.
Please,
Okay, okay, so for the huh?
in my affidavit, it's annexed.
Government of Assam in Uday Assistant,
Financial notice.
while election duty during conduct of general election to Lok Sabha.
Yes.
Okay, so for Lok Sabha, it is 50,000.
So taking the spirit from this notification, my lord, he has done the necessary compliance, my lord, and the department.
And this, and he was injured due to a
Panchayat
Panchayat
election
election.
2007.
Now, well, kindly come to page 45, man. 45.
So unless and until government has given that 25,000, another 25,000, we are not able to.
Who are you? Who are you?
I'm the deputy commissioner. Yes, that's one number.
Page 45 is the letter of deputy commissioner.
Huh?
45.
Yes.
Forwarded to the commissioner Panchayat and Rural Finance after taking the proposal out.
To the president.
My humble submission on this part.
Just a minute.
The relevant to paragraph number. Page 40. In this regard, it may also be mentioned that though there is no specific instruction from the State Election Commission attempt for compensation against that, but in view of the instruction of the Honorable High, the claims of the petitioner may be considered in the 3 of the office memorandum, page 490. That is my last Lok Sabha notification. On the basis of the medical report and other related papers, the injuries are not serious in nature and not require any hospitalization. So after but careful assessment, it is requested that the fourth paragraph of the above mentioned poem, an amount of 50,000 shall be paid to the person engaged in the election duty who received non-reverse injuries from fire.
Okay, your injury is due to what?
Due to an attack, move attack in the manner of fall.
Bomb attack. Who bomb?
Yes.
So there was a bomb explosion.
No explosion, attack, physical attack.
Wait,
No, but then this talks about
My lord, any other
receive non-grievous injuries from a firearm
or any other weapon.
or any other weapon. So what is their weapon?
My lord, physical matter.
No. This is not the weapon. Sorry. Or in a bomb explosion or by any other weapon.
Any other mistake.
Any other.
Yes. So this is information of the deputy commissioner, my department of physical. Commissioner himself will be component of
Anyway, Deputy Commissioner, let us see the court order. Court order.
error 9 last year.
The order is of 11/2/22. Here, page 45 is of 28/6/23. At the time the order was passed, this
28 to 23 was not applicable.
No, my lord, it is mentioned, my lord, page number 35, my lord, kindly, my lord. The payment, my lord, data, it is mentioned as per 8419, my lord. And
That is with regard to Lok Sabha, Lok Sabha.
my lord, kindly this data, my lord, this department of the payment data. This payment data, it is mentioned, my lord, 8419, the reference, my lord. Yeah. The department. Where we have 8419 paid, my lord. And my lord, the deputy commissioner has.
Just a minute. OPD please.
Yes, sir. Yes, yes. Manage the name, see his figure measure.
What kind of injury did you have?
Manage the name measure. How both knees you are and both the eyes measure. You are doing the repetition measure. But I think that's
I think it's okay.
my humble fair measure as per FOIA measure, he is entitled for 50,000 measure. And it is reflected from the letter of the deputy commissioner.
Nowhere has the court said that it should be as per that. Right. Mr. M. J. Patil, and counsel for the petition. Also heard Miss M. Burman for
Respondent number 2.
point number 2. And Mr. R. Dubey for point number. The petitioner. Case is that. Yes, we do here. During, during the election. During the Panchayat election briefing on 9/1/2008. Yeah, that is 2008. This is 2019. Where's the question?
How? My lord, that case is pending.
Anyway, Mr. Counsel, I've closing it. I've closing it.
Better to get a interest, my lord.
I've closing it. This is a contempt, nothing to do with you. It's only between you, them and me.
As per FOIA, my lord, I should not pay.
No, no, no.
Yeah.
Okay, the contempt petitions have closed.
If you.
So, applying button. But they quite limited for a week.
Yes, who is appearing for the BTC?
But it's the authority of it, the beginning on making some other.
It's only the issue of, it's the issue, there's nothing now. It's only that financial sanction
I understand.
has been made, it appears. So now what is happened? Have you talked to your client? Yes, Mr. Chavez, what has happened?
Logic, the last of the, we have started making the payment, but not in full payment. Logic, part they have been going up. And the last time I explained from record, 5 lakhs have been given. As on the space act of the giving part payment, again, logic, again.
How much have you got to pay to this person?
Logic, earlier payment was, I think now it will be 20 something. 27,600.
27 lakhs 60,000.
Correct, it's the 3,000. Have counsel for the respondents have been in practice that to why the remaining 27,50,000 are not been paid to the pool. This is the matter after forgiving. Good.
Right, so the office, housing board, what it is first of May, madam. Service upon the response, private respondent is complete. For the 4, 5, and 6. So it may come up for execution. Along with, there are two other connected methods, madam. 607 of 2024 and 279 of
Correct. As per the Navadvip court proceedings dated 1/5/2023. Service in respect of the respondents number 4 to 6 is complete. If the head counsel for the petition says that the matter may be listed along with WPC
607 of 24
307 of 20.
and 2729.
No, no, what is it? 207 of 20. When? Our two.